processed it with Cindy and her husband. Ben, he read it. Todd, he actually wanted it slanted more towards her. Ben, to inoculate her. Todd, so that she would take more responsibility. At one point during the conversation, the cell phone rings and Representative Korzer identifies the caller with a female voice as Representative Gamrat. Todd, Ben and I are sitting here. He's trying to mentally process everything I just told him. So trying to find a different way. So what are your thoughts? You can't really, because then there's a record of that, and I'm not there. No, I haven't. I'm still heading in that direction if Ben was trying to figure out if there's a way to go, and I think it's good. I'd rather have him question all this, the route of which, but you see another option there. Another option there, Cindy? Okay, can I call you if we have any other questions? If I have any, I won't call him unless I do. What's that? No, I'm just saying that because I'm sitting here right now, it's what I'm saying. I'm saying, do you have any other thoughts on it, is what I'm asking you. We're still talking about it here. Okay, bye-bye. Representative Korzer then continued to press Mr. Graham about sending the email. Todd, I want people to delete it and mark it as spam when it's done because they're so effing pissed that somebody sent out a piece of garbage into their inbox. That's what I want. Does it get us there? Ben, I guess it does, but it's going to hit the media. Todd, I want it to hit the media. Representative Korzer then read the email a second time, and he and Mr. Graham made changes to the draft. The meeting ended about midnight. Mr. Graham left to think about it and go for a drive. Later that morning, Mr. Graham informed Mr. Korzer that he would not be involved in the cover-up plot. The false flag email was sent the following day under the pseudonym George Rathburn. It reads in its entirety. From George Rathburn 520 at gmail.com. Sent 5/20/2015, 11:36 a.m. Subject, breaking scandal, Todd Korzer. Breaking scandal. State Representative Todd Korzer caught behind Lansing nightclub. Christian conservative or godless addicted monster. Truth. Korzer secretly removed from caucus several weeks ago due to male-on-male paid sex behind a prominent Lansing nightclub. Action soon coming to remove Korzer. He is a bisexual, porn-addicted sex deviant. All over Lansing since the election. That is why he was thrown out of caucus. He's a freak. He's a gun-toting, Bible-thumping, cocksucking freak. His whole personality is a sham. He is a tool pawn of the establishment. In past election, he was accused of child molestation, and he's done things that should have him in jail. He doesn't work in Lansing. He is just there feeding his habit of alcohol, drugs, and illicit sex. Most day he is high, stoned on drugs and alcohol while he's supposed to be voting in the State House. Representative Gamrat knew it all along and has helped cover his actions. Has played along with and been complicit in his sordid activities and has covered for him over and over, and her involvement is the real reason she was thrown out. She shouldn't ever have been trusted as state representative and national committee woman. She is a tramp, a lie, and a laugh for this bisexual cocksucking monster. This teabagger takes his title seriously, moaning and groaning, fucking and screwing man on woman, and whoever he can pay. Pictures and video, YouTube, tell this whole story and all the exploits behind the nightclubs and hotels at some of the best and worst places in Lansing with all the grinding, hot and sweaty sex and drug use. It is too much to hide anymore. He is a scam. That's the end of the email. The day after Representative Korzer had the false flag email distributed, Mr. Graham met with both Representative Korzer and Representative Gamrat in the latter's office. During the meeting, there was a lengthy discussion about the representative's affair and marital issues, along with Mr. Graham's intentions and feeling about the matter. Representative Korzer told Mr. Graham that Ike sent the false flag email. He added, well, like he's done other things in the past as well, and he's the guy, obviously, that, I've done some things for, and he's done some things for me as well. Mr. Graham confronted both representatives about the affair. He repeatedly asked how long the relationship had been going on. Representative Korzer responded that he did not know the specific date, but that it wasn't back in the beginning and it wasn't yesterday. Mr. Graham replied that he did not think representatives could reconcile their situation by covering it up. It's going to come out. Representative Gamrat discussed her own reasons for engaging in the affair. She apologized to Mr. Graham for putting him in a difficult position and stated that she wanted to keep the affair private. Mr. Graham, however, refused to be part of any cover-up. Ben, that's your guys' decision. I won't be involved in any. Todd, cover-up. Ben, any cover-up. Both representatives continue to state their wish to keep their affair private. At one point, Representative Gamrat implored, I would ask you, Ben, just to keep it private. It's not just about protecting me, it's about protecting Joe and the kids. Throughout the meeting, Mr. Graham attempted unsuccessfully several times to get the representatives to discuss the upcoming House session and go to committee meetings which were taking place during the discussion. Representative Korzer missed a joint meeting on the House Standing Committee on Oversight and Ethics and the House Standing Committee on Military and Veterans Affairs. Mr. Graham recorded 2 other meetings with both representatives. These meetings occurred on May 26, 2015 and June 9, 2015, and both occurred in the House. Accordingly, of the 4 discussions secretly recorded by Mr. Graham, only one, the first, took place after hours off House property. Subsequently, on July 6, 2015, the at-will employment of Mr. Graham and Keith Allard, Representative Korzer's and Representative Gamrat's Chief of Staff, was terminated. On August 7, 2015, the Detroit News published Chad Livingood's article. The ensuing investigation began. During the investigation, Mr. Graham made available to the House the 4 unedited audio recordings he made. In addition, staffers provide a large volume of emails to the House Business Office. The evidentiary record compiled by the House Business Office, preliminarily the audio and emails confirmed the number of additional acts of wrongdoing by representatives. These include Representative Korzer had staff forge signatures on 3 bluebacks bills to be introduced to subvert the efforts of other representatives to introduce similar legislation. Representative Korzer consistently berated and belittled the office's combined staff. Representative Korzer yelled at his staff for not getting work done over the President's Day weekend and for failing to know certain legislative details, while in the same email proudly exhibiting his ignorance about the most basic of legislative tasks. Email quote, when something isn't done and hasn't been administered and I shouldn't have to be schooled from my staff on where my time should be spent and invested. I am damn sure it's not my role, it's not the role of my staff in Lansing or in Lapeer to push me back on items that they are being administered or not being administered. If I say I want a warrant provision and notification provisions or adjustments to a bill, then you damn well better put that item and any item like it on your radar and calendar it out in your task tracker and your daily activity log, all of which need serious work and some of which totally were unused and not being administered. If you are admitting anything, better know the drop dead date. Bold, because I do not know these things and I shouldn't have to. And then you need to know the time and then make sure we have submitted before any of your 24 holidays. To then tell me it's because we didn't meet on Thursday is disrespectful and untrue, given that you have a full work week on full work day on Friday to deal with it and get in the motion, and it shows a lack of understanding of what my role is and what responsibility staff has and who's in charge. In bold, I do not know the amendment process, nor should I have to. Am I right on this, or am I missing something here? End of email. Last point, Representative Korzer and Representative Gamrat failed to create and maintain clear lines between legislative and political work. Sorry, that wasn't the last point. In their combined offices. Numerous examples of the blurring of the lines can be found in the office emails. While the representatives occasionally note that political campaign work should be done during private hours off House property, they often demand that certain political campaign work take precedent over housework and that the former be done during a time when any reasonable person would understand to be House time. As a part of this blurring of legislative work and political campaign work, Representative Korzer had the combined office set up to use Nation Builder, a database program designed and used for political work. All constituent requests sent either to Representative Korzer or Representative Gamrat were entered into the Representative's Nation Builder database. It appears that such information was then used for political campaign purposes. Representative Korzer made clear that he has not asked for or expected, but rather been demanded as a condition of their House employment that staff do political campaign work for both Representative Korzer and Representative Gamrat. Moreover, Representative Korzer instructed staff to prioritize political tasks over legislative issues during normal operating business hours. Now, last point. Staff members were instructed to assist in the development and placement of social media advertisement in Representative Korzer's law firm. Thank you.
Fundamentally, membership in the Michigan House of Representatives is a privilege, not a right. Accordingly, similar to the U.S. Congress and other state legislatures, the Michigan House of Representatives is the sole judge and jury of its member discipline. The purpose of member discipline is twofold. One, to punish wrongdoing, and two, to protect the institutional integrity and reputation of the legislative body. Legislative bodies, including this House, have three basic tools of discipline at their disposal, increasing in the level of severity: reprimand, censure, and expulsion. A reprimand is basically a formal vote of disapproval of a particular action taken by a representative. The House reprimands a member by passing a resolution with a majority vote. Typically, no conditions are attached to a reprimand. The House can also censure a representative. A censure is a more serious level of disapproval than a reprimand. It, too, is passed by a resolution with a majority vote. The main distinction between a censure and a reprimand is that conditions on a member's service typically accompany a censure. For example, a representative could be stripped of committee assignments as well as any authority or input over staff or expenditures of their office. A censure is appropriate when a member commits an act of misconduct related to official duties or commits an unofficial act of a kind likely to bring the House into disrepute. Finally, with the Constitution of 1963, the people of Michigan charged the House with being the sole judge and jury for whether a member should be expelled. Specifically, Article 4, Section 16 provides in full, quote, "Each House shall be the sole judge of the qualifications, elections, and returns of its members, and may, with the concurrence of 2/3 of all the members elected thereto and serving therein, expel a member. The reasons for such expulsion shall be entered in the journal, with the votes and names of the members voting upon the question. No member shall be expelled a second time for the same cause." Close quote. According to an earlier Michigan Attorney General opinion, expulsion disqualifies a person from serving as a representative for the rest of that legislative term. But an expelled member is eligible to run in the following election, assuming there's no bar otherwise, such as a term limit. When looking at censure versus expulsion, there is no bright line standard adopted by all legislative bodies to distinguish between the two or determine when one is appropriate over the other. The standard is instead the collective judgment of that particular body. While there is no bright line rule, precedent does provide a common theme. In Ray Chapman, the U.S. Supreme Court explained that conduct so egregious as to justify expulsion is that which is, quote, "inconsistent with the trust and duty of a member," close quote, or the abuse of one's office, even if that behavior did not violate the law or was not done in the member's official capacity. Similarly, during the expulsion process for Senator Jay, then Senator Sikkema stated on the floor in the Senate, and I quote, "Now some say that he should not be expelled because he has not been convicted of a felony, and that a felony conviction is, has been, and should be the standard for expulsion. This is a myth. Nowhere in the Constitution or Senate rules do we find such a standard. The standard is a level of behavior that fails to, quote, maintain the integrity and responsibility of his or her office," close quote. It is simply unacceptable to tolerate a pattern of behavior that clearly brings dishonor on the Senate just because it doesn't include a felony conviction. Now, this does not mean that every senator who has had a run-in with the law or experienced a personal failing should be expelled from office. We are all human, and we would all fail the standard of perfection. But we are not addressing a pattern of behavior that is either typical or excusable. Others say that we should let the voters of Senator Jay's district decide. You know, the voters do have the ultimate power to decide because they can overturn a decision to expel the senator by returning that person to office. But that doesn't alleviate us of our constitutional responsibility to pass judgment on a standard of behavior that we believe is acceptable or unacceptable. It is this principle, gleaned from multiple sources, that an act or a pattern of acts that is so egregious or atypical that it, one, calls into question the trustworthiness or judgment of a representative, and two, brings disrepute to the legislative body, that the Michigan House of Representatives should apply in determining whether expulsion or censure is warranted here. Under any standard of appropriate behavior, Representative Courser has failed in miserable and spectacular fashion. First, he had an extramarital affair with another sitting representative. While in and of itself not so outside the norm of society as to require expulsion, the personal nature of his transgression should not obscure the fact that he breached a fundamental trust in committing adultery. Second, and more egregious and more atypical, Representative Courser tried to hide his adultery in quite possibly the most bizarre attempt at misdirection seen in the history of this legislature. In his own words, Representative Courser intended to, quote, inoculate the herd, close quote, a rather callous way of describing his constituents, by mixing in, quote, a little bit of truth with a lot of lies, close quote. But not only was he trying to misdirect people away from his affair, he was also trying to smear preemptively anyone who would actually tell the truth about him. Quote, but anything after that is going to be suspect. It will be looking like a complete smear campaign, close quote. This view of truth and lies, where such things are merely weapons to use against one's political friends and foes alike, falls far short and below any standard of appropriate conduct for a sitting legislator. And the misdirection plan cannot be explained as a one-off mistake caused by extreme stress. At least with Representative Courser, the false flag email scheme was something he had in the back of his mind for years. Quote, been thinking about this since I ran for office 2 years ago or 3 years ago, whenever we did the last time out, close quote. This level of cynicism, while maybe acceptable in an undergraduate philosophy course on nihilism, has no place in the Michigan House of Representatives. That the scheme appears not to have violated any statute does not absolve Representative Courser of his wrongfulness. Third, Representative Courser tried to recruit Mr. Graham into this bizarre scheme. Mr. Graham had known Representative Courser for approximately 10 years and had worked on all of Representative Courser's political ventures. He looked up to Representative Courser as a mentor. And needless to say, he was a House staffer who reported directly to Representative Courser. Even though Representative Courser explained the scheme to Mr. Graham after hours, off-state time, and even though Representative Courser asked him to participate in the scheme using a non-House email and off-state time, it was still highly inappropriate for Representative Courser even to ask. Fourth, Representative Courser continued to talk to his staff about the affair and cover-up during work hours in the House office. In doing so, he intentionally avoided performing legislative work, including attending committee. He asked his staff to help him cover up his affair by, for example, not telling anyone about it and prohibiting them from disclosing his true whereabouts to family members. Together, the affair, the bizarre and atypical attempt at covering it up, the avoidance of legislative work, and the enlistment of House staff in this mess are alone sufficient to warrant expulsion under the principles stated earlier. 1. The actions call into question both the trustworthiness and the judgment of Representative Courser. And 2. The actions have already brought the Michigan House of Representatives into disrepute and ridicule. Yet, unfortunately, there's additional behavior that similarly fits the bill. Fifth, Rep. Courser required staff to forge his and Rep. Gammert's signatures on at least 3 bluebacks. This is a clear violation of House Rule 41-1, which provides in relevant part, quote, all bills to be introduced shall be approved as to form and numbering of sections by the Legislative Service Bureau and be signed by the member introducing them, close quote. This fits within Rep. Courser's cynical view of how he thinks the House operates. Sixth, this cynical view was repeatedly thrust upon his staffers. As noted above, there are numerous examples where Representative Courser makes clear his disdain for the processes and procedures of legislation. including one of the most central, if somewhat mundane, procedures, amending a bill. Seventh, Representative Courser was a bully to his staff. He berated them, threatened them, and demanded that they do things that no staffer should be asked to do. Eighth, Representative Courser impermissibly mixed legislative with political campaign matters in his office. The House provided both representatives and staff with clear guidance on the need to keep these matters separate. For example, in the Principles and Guidelines for House Staff, drafted by House Legal Counsel, a document that both representatives and staff receive when they start, as well as periodically throughout the 2-year session, it is explained, quote, House resources, for example, your time on the job, office space, office property, equipment, and supplies, must be used only for official House business. The use of House resources for non-official House business, for example, campaign, fundraising, commercial, charitable, or personal activities, is strictly prohibited. You may volunteer your time for campaign or fundraising purposes during normal or office hours. You must do so, however, on your own personal time, and you must record your hours off on your timesheet. As a state employee, you are a steward of taxpayer funds and have a heightened duty to safeguard public resources from misuse for political purposes. Campaigning for office is wholly distinct from serving in office. Do not mix the two. Close quote. Now, unlike several of the other matters that I've already discussed, the evidence on this point is not completely one-sided. Representative Courser and Representative Gamrat did recognize on several occasions that political campaign work should be done off-premises during off hours. There are emails in the record to show that. Yet the weight of the evidence confirms that, at best, Representative Courser took a very lax attitude toward keeping legislative work separate from political campaign work. Given all of his other transgressions, such an attitude only confirms his lack of respect for the House as an institution. Ninth, there is some evidence that he used House resources for his personal law firm work. The evidence collected by the House Business Office on this matter is not so overwhelming to justify, in and of itself, expulsion. Yet, together with the other evidence of wrongdoing, especially the lax attitude toward mixing legislative work with other work, the evidence involving his law firm is consistent with the general pattern of disrespect. And more importantly, such evidence does suggest that additional inquiry by law enforcement would be appropriate after the House has completed its constitutional duty. 10th, in the days after the Detroit news story broke, Representative Courser has failed to appreciate or even acknowledge the extent of his wrongdoing and has shown little true remorse. There have literally been hundreds of news stories with damaging headlines referencing, quote, a House sex scandal, close quote. The false flag email cover-up has even been the subject of a late-night comedy skit on television by Jimmy Fallon. In fact, instead of trying to repair the damage he caused to the House's reputation, Representative Courser chose to attack the integrity and legitimacy of not only the House Business Office, but also the Select Committee, which he called a kangaroo court before the committee had even held its first hearing. It is incontrovertible that Representative Courser's actions have brought disgrace to the House, and correcting that type of negative attention is precisely why expulsion exists. Given this evidentiary record, one based on incontrovertible audio recording and emails, confirmed as accurate by Representative Gamrat herself this morning, it is hard to fathom how Representative Courser's trustworthiness or judgment would not be called into question every single day he remains in office. It is equally hard to fathom how a select institution, one with 110 members usually, that has Representative Courser as a member would not be continuously subject to disrepute. For the good of the Michigan House of Representatives, the constituents of the 82nd District of Michigan, and the state of Michigan as a whole, Representative Courser should be expelled immediately from the House. Now, if history is any guide, then the Select Committee should expect that Representative Courser will attempt to defend his actions with his favorite weapon of choice, misdirection. The Select Committee, however, has a narrow jurisdiction, namely, to consider the qualifications of Representative Courser and Representative Gamrat as representatives, no more, no less. Moreover, the Select Committee unanimously adopted Rules 8 and 10, which provide that irrelevant, immaterial, or unduly repetitive evidence must be excluded. Information is not relevant unless it is both, one, has a tendency to make a fact more or less probable than it would be without that information, and two, the fact is of consequence in determining the action. Accordingly, the Select Committee has the mandate and the tools to reject any attempts at misdirection by Representative Courser. What can the Select Committee expect to hear from Representative Courser? That is truly anyone's guess. Though a good place to start is what Representative Courser has been saying since the Detroit News article broke on August 7th. Following is a sample of what Representative Courser has publicly said in his defense of his actions. Am I being targeted as a form of political retribution? Quote, given my voting and my advocacy for conservatism are among the best in the legislature, maybe I shouldn't be surprised that I am singled out and put on a fast track of expulsion, close quote. The response to this, it's irrelevant to the qualifications of Representative Courser. But in any event, there is no mention of why other representatives who have similar voting and advocacy records are not being similarly targeted. Is this a political hit? Quote, this all comes down to tapes made by disgruntled former staffers possibly working with the Speaker's office that show conversations about family and conversations concerning politics, close quote. The response, this is irrelevant to the qualifications of Representative Courser. In any event, the conversations about family, while sad and disturbing, are not the point, nor are the conversations about politics. The relevant parts of the audio recordings include the infidelity, the fidelity, the cover-up, the false flag email, the lack of concern for legislative work, etc. Next, does the alleged misconduct support expulsion or another lesser penalty? Quote, Speaker's office employs staffers and places them in the representatives' offices. The staff works with Speaker. The Speaker handpicks the evidence, and I will be given little to no ability to defend myself. The response, that is irrelevant to the qualifications of Representative Courser as a representative. But in any event, Representative Courser was the staffer's immediate supervisor. Moreover, he was given ample time to study the audio recordings and emails, and importantly, he was the main actor in all of the audio recordings and all of the emails. He should remember them. Next, I should have been warned about the audio tapes. Quote, the tapes given an account of hours of meetings, albeit taped during the time when I am eating lunch, noting conversations that are of personal family nature and some focused on political conversations, close quote. The response, this is irrelevant to the qualifications of Representative Courser. In any event, the substance of the audio recordings cannot be blamed on lunch. Next, was this an attack on an activist leader who was at odds with leadership? Quote, I repeatedly challenged the progressive steps of leadership, close quote. The response, this is not relevant to the qualifications of Representative Courser as a representative. In any event, other members of the Republican caucus have challenged leadership on policy, and my friends in the Progressive Party or the Progressive camp would likely not agree with Representative Courser's description of what progressive means. Next, was this the case of a political hit? Quote, hours of tape, secret meetings by the taping staff members with the Speaker's office, no warnings provided, close quote. Response is irrelevant to the qualifications of Representative Courser. But in any event, no recording was done with the Speaker's office knowledge or direction. Next, why the rush to judgment? Quote, there is a police investigation into the alleged extortion wiretapping by the anonymous texter, close quote. Response, it is irrelevant to the qualifications of Representative Courser as a sitting representative. As explained by the House Business Office, quote, throughout this investigation, Representative Courser failed to appreciate that the blackmail allegations have no bearing on whether he engaged in misconduct or misused state resources, close quote. And in any event, neither the Attorney General, the Michigan State Police, nor the Lapeer local prosecutor is charged with determining whether Representative Courser should be expelled from the Michigan House of Representatives. Under the Michigan Constitution, only the House can answer that question. Next, has there been a thorough investigation of the tape recordings? Quote, staffers were in constant contact with the Speaker's office. Were these the only tapes? Do the staffers have more? Does the Speaker's office hold more? Are these tapes authenticated? Close quote. Again, the response to that is all of that is irrelevant to the qualifications of Representative Courser as a sitting representative. However, in any event, the staffers have confirmed with the House Business Office that there are no other audio recordings. Before the investigation, the Speaker's office never possessed the audio recordings. Finally, as you heard this morning, Representative Gamrot has stated in written testimony and oral testimony to the Select Committee that the audio recordings and the emails are accurate. Next, were the staffers competent or incompetent? Rep. Courser has publicly claimed that his staffers were let go because they were, quote, incompetent, close quote, and ill-suited to run a legislative office. The response is, this is again irrelevant to the qualifications of Representative Todd Courser. In any event, whether the staffers were stellar, competent, or incompetent is of no moment to whether Representative Courser mistreated them, berated them, asked them to cover up an affair while talking in a House office and missing House committee assignments, etc. The hard, incontrovertible evidence in the record, the audio recordings, and the emails establishes without a doubt that Representative Courser did all of these things and more. Next, why hasn't the Speaker's office given a full account of meetings with former staffers? Quote, the Speaker's office is directing the investigation, but can they investigate their own conduct or misconduct and issues related to the investigation? Close quote. The response is that is irrelevant to the qualifications of Representative Courser as a representative. In any event, as part of the House Business Office's investigation, the Speaker's office did provide statements with regard to meetings with staffers. Importantly, as I noted earlier, the Speaker's office did not possess the audio recordings or the emails that confirmed the egregious actions taken by Representative Courser prior to the investigation. Moreover, when someone heard about the Representative Courser's bizarre behavior is of no consequence to the question of whether Representative Courser did, in fact, engage in bizarre behavior. The precise moment when the Speaker's office came to realize the scale and scope of Representative Courser's transgressions is as relevant to the qualifications of Representative Courser as is the precise moment when Minority Leader Grimal learned, the Michigan Democratic Party learned, the Michigan GOP learned, Chad Livengood learned, or frankly anyone else similarly came to realize the scale and scope of his transgressions. Now to this last point, I would like to take a moment of latitude and get into something that is not relevant to the transgressions of Representative Courser, but that I know is of much interest to some. And now I can actually talk about it. As I explained during my interview with the House Business Office, I met a single time with Ben Graham prior to his termination from the House. It was shortly after the first meeting he had with Representative Courser, when Representative Courser asked him to participate in that false flag email. The meeting was intended to be a confidential one, and I was not provided any audio recording of the conversation between the two. In fact, the first time I ever heard the audio recording or read any of the emails was when the Detroit News broke the story on August 7th. Ben explained during the meeting that Representative Courser had asked him to participate in a crazy scheme, but that Ben had said no. He also mentioned, as I recall, that someone named Ike was likely going to help Representative Courser send out the email. Ben absolutely did the right thing by refusing to get involved in this nonsense. This was not appropriate, the scheme. With that said, based on that conversation, I concluded that the allegations by Ben amounted to Rep. Courser intending to send an anonymous email about himself from a non-House email account off House time and without the aid of House staff. Moreover, the email was allegedly going to be about a personal matter, namely the sexual and drug habits of Representative Courser. There was nothing illegal that I could see with the alleged email scheme, as it would have been defamatory only against the person who was going to have the email sent. In other words, self-defamation is not illegal. I could not think of any other way that the email could be illegal under the circumstances. Given this, I believe that under the law, I could honor the confidentiality of the conversation under Michigan Rule Professional Responsibility 1.6 and case law that interprets that rule. Yet, given the public investigation, I am no longer bound by this confidentiality regarding the meeting, so that is why I'm explaining it here. I want to reiterate that Ben Graham did the right thing in refusing to get mixed up with Rep. Courser's crazy scheme. If Rep. Courser wanted to engage in self-destruction, then he alone should be the one to do it. Now, returning to the matter to which this select committee is charged, if Rep. Courser is expelled from the Michigan House of Representatives, then how can Rep. Gamrett remain as a representative? Frankly, the question is not one easily answered. Yet, based on a review of the record evidence, Representative Gamrett appears to have been an accomplice more than a principal, at least with respect to several of the major transgressions. Clearly, it takes two to engage in an extramarital affair, and she is just as much a principal in that act as Representative Courser. In other respects, however, she is just as clearly an accomplice rather than a principal. For example, in her statement before the Select Committee this morning, Representative Gamrett admitted that she agreed to the sending of a false flag email, but she contends that she did not know how over-the-top and absurd it would actually be. Similarly, she admits that the combined staff was treated poorly, but she denies that she personally berated them or otherwise mistreated them. She should have done more to protect her staff from Representative Courser's behavior, she admits in her statement. Now, most witness statements are self-serving in some respect, and for that reason, I suggest that all statements be taken with a healthy grain of salt. In this instance, however, the emails and the audio recordings largely corroborate that Rep. Gamrett was a principal for some actions, but an accomplice for most. In contrast, the emails and the audio recordings confirm that Representative Courser was a principal for all of the actions. In many circumstances, an accomplice can be held just as legally liable as a principal in a court of law. Yet the House does not sit as a court of law, and the House can make a material distinction between the punishment appropriate for an accomplice versus the punishment appropriate for a principal. In addition, the post-revelation actions of Representative Gamrett should be contrasted with those of Representative Courser. Representative Gamrett has publicly apologized without trying to deflect blame. The same cannot be said of Representative Courser. Moreover, Representative Gamrett has set office hours, tried to reach out to constituents, and engaged in actions that are consistent with her position as a representative of the 80th District. Representative Courser has done nothing of the sort. Instead, he has spent his time drafting mini manifestos on social media. In the final analysis, the distinction to be drawn, if any, between what Representative Courser and Representative Gamrett did is likely one of degree, not one of kind. Both engaged in wrongdoing, and both showed terrible judgment. It is for the Michigan House of Representatives to decide if and how to punish Representative Gamrett for her role in the affair. Yet, given what appears to be her accomplice role, as well as her post-revelation acts of contrition, it is recommended that she receive a censure with severe conditions rather than expulsion. Finally, in conclusion, in his audio apology issued several days after the Detroit news story broke, Representative Courser compared his plight to that of the Founding Fathers. Were the Founding Fathers still alive, that would have been defamation. It is true that the Founding Fathers exhibited many personal faults, but they also had incredible redeeming qualities: keen intelligence, broad statesmanship, sound judgment, and near universal credibility, just to name a few. As the audio recordings and emails compiled by the House Business Office have shown, Representative Courser exhibits some of the personal faults of our Founding Fathers, but he exhibits none of their redeeming qualities. For the reasons explained here today, it is my recommendation that Representative Courser be expelled from the Michigan House of Representatives. With respect to Representative Gamrett, there is sufficient evidence in the record to suggest that her role in the affair, cover-up, and other wrongdoing was a mix between principal and accomplice. Given this, and given her actions since the Detroit news story broke, it is my recommendation that Representative Gamrett not be expelled, but instead that she be censured with severe conditions attached. That's the end of my testimony, and I'm happy to take any relevant questions you may have.
Thank you, gentlemen. I know this has been a lot of work for you over the past month, and I appreciate the very hard work that's gone into all of the investigation and preparation of these reports. Members, at this time, are there any questions? Vice Chair Heisey.
Thank you very much, Mr. Chairman. Mr. Schwartzel, I'd like to know, in your opinion, what can be included in a censure? What types of punishments may be included in a censure?
And then Mr. Bowen may also be able to help me on this, but I do know that committee assignments can be either restricted or taken away altogether. Office allotments can be restricted or taken away altogether. Staff can be restricted or taken away altogether. I have no doubt that there are other restrictions that I'm not thinking about. Monetary penalties are also a possibility.
Really anything associated with the allotment account, so mailings to the district, any mass communications with the district, which is primarily the main focus on allotment side from staff. So all those could be affected.
Other questions? Vice Chair Turkin.
Through the chair, I'd like to ask Mr. Schwartzel if this is his recommendation or the Speaker's recommendation that he's read on the record today.
It is mine as General Counsel. And just to clarify, I'm not speaking for the Speaker here.
Okay, thank you.
Representative Reali-Tea.
Yeah, Mr. Bowen, is it also your opinion that Representative Courser should be expelled and Representative Cameron should receive severe censure?
I would agree with the findings of the General Counsel, yes.
Thank you. Another question, please.
Just curious, do you have a dollar figure on what the misuse of state funds may have been, the cost to the state, any time figures or any dollar values?
We've not gone through to calculate that, but it is not, I don't want to say it's not a significant amount because that's in my mind, and you may have a different idea of what is significant, but I think we're talking about low thousands, 4 digits. I don't think we're getting into 5 digits or 6 digits, certainly. You would take the amount of staff time that was devoted to this, you would, the minutes or hours, and you would calculate something. Frankly, I don't know that that's even possible to do in retrospect, and it would probably cost more for my office to figure it out than it would be than the number that would come up with that. So at the end of the day, if a monetary penalty is deemed appropriate, I would suggest coming up with a best estimate rather than trying to track down every single minute, because that's going to be costly.
Yes, Representative, and we do know the hourly rate of all the individuals involved that worked in the offices. So the hard part for us is trying to figure out exactly the number of hours that were incurred doing either personal work on behalf of Representative Courser or political work on behalf of either representative. So we'd have to delve into that a little bit further, and I would agree with Brock's estimate that it probably is in the thousands, low thousands, I would think.
Thank you, Representative. Other questions from the committee? Or from council?
If we need to question these individuals later, can they be brought back?
Go ahead, speak. So
Okay, I'm sorry. If we need to question these individuals, can they be brought back later?
Yes, absolutely.
Okay.
Representative Reali.
Thank you, Chair. I guess for either of you two, actually, Mr. Bowen, you stated if you found any information regarding actions that broke laws, you would not wait until after that investigation was completed before turning that information over to the Attorney General or Michigan State Police, correct? Did you find anything that you did turn over?
I did not at this time. Representative, when we're looking at the violations relative to use of state resources, if we're turning anything over, it'd probably be to the Secretary of State. So no, I did not.
Okay, thank you.
And just to follow up on that, the Secretary of State would be brought in on any campaign finance issues. That's under the law, that's where we have to start. One of the benefits of having Exhibit 2 be essentially the entire record is that now, frankly, anyone can look at it, and if a law enforcement agency determines that follow-up is necessary, then that's possible. We will keep the unredacted version until any statute of limitations has run.
Other questions, committee members or council? Representative LaFontaine.
Thank you, Mr. Chair. This question is for Brock. In your opinion, do you believe that if either representative were granted the ability to stay in office, that they would be able to execute their duties and responsibilities?
I believe Representative Gamrett, there's hope for her to be an effective representative. I don't know if I were a betting man whether I'd put any money on that, but I do think that there's a chance for her to succeed. Representative Courser, I have no belief that he could be an effective representative. He has, with his actions here that have been documented in the audio, in the emails, he has burned any credible bridge he had to be an effective representative, in my opinion.
Any follow-up, Representative LaFontaine? Mr. Schwartzel, would you say that public trust has been pretty much obliterated, and that's what hinders the ability to function in office continuing forward?
I think that's a good phrase, obliterated.
Okay.
Yes.
Vice Chair Heisey?
Thank you. For either gentleman, under a censure scenario or an expulsion scenario, what happens to their respective offices? I'm concerned about punishing the constituents for the next year and several months. So what would happen if the office was vacated, and then what would happen if an individual were censured? What happens to their staff? What happens to that office? If I've got a question about state government or a payment from the state of some sort, who do I call?
We absolutely believe that their district deserves assistance, and so we would assign staff to help with that district if, for example, one of the representatives is expelled. We have central staff who could do that, and essentially we would assign one or two persons, and they would be the staff for that district. With expulsion, that is really a condition that could be placed. Right now, the staff of Representatives Gamrett and Courser do not report to them. They report to Mr. Bolin in the House Business Office. And something similar to that could happen if, for example, Representative Gamrett was censured. Her staff, I would anticipate, would not report to her. They would report to either Mr. Bolin or maybe myself.
Okay, and as a follow-up to that, in the event of censure, an individual is entitled to run for, stand for election in 2016, correct?
Absolutely, as long as they're not term limited.
In the event of expulsion, are they entitled to run for or stand for election?
Same answer.
So in the event of expulsion, then the governor calls a special election just as if that member had resigned?
Correct.
Okay. Thank you.
And Mr. Vice Chair, to your comment about not wishing to punish the district, I believe it would be arguable that either way might be considered punishment to the district. Would you agree with that, Mr. Schwartzel?
I believe it would be more punishment to leave Representative Courser in place than not.
Other questions from the committee? Vice Chair Churkin.
In your report, you say that Ben Graham or Keith Allard on several occasions tried to reach out to the Speaker's Chief of Staff, Norm Sari, to discuss issues related to the various problems within their respective offices. In the normal course of business, Mr. Bowen, if anybody else would have came to your office or to Mr. Sari and asked or told you about some improprieties or what have you, what would have been your position?
Mr. Chairman, is that kind of hypothetical? Is that really relevant at this point?
I'm asking a question that I think is a pertinent question that both houses would like, the Republicans and Democrats would like to know. It's in the report. I mean, you guys did author the report findings in this brochure here, right?
I'm not sure. I'm sorry, I'm not sure what you're referring to, the statement this morning or the House Business Office report?
The report findings is in this binder.
Okay. I did not author that.
And what I want to know is, in the normal course of business, if somebody else other than these people would have came to you, what would you have done?
I still am going to maintain that objection, Mr. Chairman. I think it's irrelevant and it calls for speculation that is based on evidence that doesn't exist right now.
Mr. Shurkin, I'm not exactly sure how that's relevant to the specific question of the qualifications of either representative.
All right, thank you.
Thank you. Other questions from the committee? All right. Vice Chair Churkin?
Okay.
I was just gathering up my stuff.
I'm sorry. This is for Mr. Bowen. What is the basis of your assertion that in the report in hindsight you should have done more to investigate the complaints made by Keith Allard or Ben Graham?
I think, I did not write it, but I think I can handle that one, which is if we had known, if we had had the audio and the emails, then more would have been done. I mean, it's anytime you do an investigation, after that investigation, if you knew everything that was in the investigation, you might have handled things differently. That doesn't mean that at the time you handled it inappropriately based on the information you had at that time. His hindsight is 20/20, and I don't think anybody who looks at this record would suggest that Representative Corser was acting appropriately.
Thank you.
Thank you, Vice Chair Churkin. Any further questions at this time? All right. Okay. Committee members, you've received a letter from Representative Corser just before the meeting began. At this time, we'd accept a motion.